Chapter 13. The Estes Documents. The 1984 grand jury testimony of Billy Saul Estes accomplished only one official action. Henry Marshall's death certificate was finally changed to read, "Cause of death, murder by gunshot." But at the same time, the proceedings attracted the attention of the United States Justice Department. Estes received an official letter requesting a meeting to discuss the provocative charges he had made before the grand jury. Estes enlisted the legal services of Douglas Caddy to represent him in this matter.
In August of 1984, I sat down with Billy Saul Estes in his home in Abilene, Texas, and the only other person present was his daughter Pam Estes. And he disclosed to us what he knew. And I put this in a letter dated August 9th, 1984 to Stephen Trott. I indicate in that letter that Mr. Estes is willing to testify about the following murder.
Caddy corresponded with the Justice Department in an attempt to secure the protection of immunity from prosecution for his client. A few months after the release of the Men on the Sixth Floor, I received 2 of these letters of negotiation between Estes and the Justice Department. We made these letters public by including them in the second edition of our book, and now we include the remaining 2 letters that have made their way to us in this our updated edition. None of the documents have been previously available prior to their publication by us. And because they reflect the sensitive negotiations between the government and a private citizen, it is unlikely they would ever have become public, had it not been for certain sources who, after reading the first version of our book, The Men on the Sixth Floor, were compelled to send this information to us, and we thank them for that. We now present all 4 letters, the complete record of correspondence between Billy Saul Estes and the United States Justice Department. Letter number 1, dated May 29th, 1984, U.S. Justice Department, Criminal Division. Douglas Caddy, Attorney at Law, General Holmes Building, 7322 Southwest Freeway, Suite 610, Houston, Texas, 77074. Dear Mr. Caddy, regarding Billy Saul Estes, I have considered the materials and information you have provided to me in connection with your representation of Billy Saul Estes. I understand that Mr. Estes claims to have information concerning the possible commission of criminal offenses in Texas in the 1960s and that he is willing to reveal that information at this time. I also understand that Mr. Estes wants several things in exchange for this information, such as a pardon for the offenses for which he has been convicted, and immunity from any further prosecution, among other things. Before we can engage in any further discussions concerning Mr. Estes' cooperation or enter into any agreement with Mr. Estes, we must know the following things. First, the information, including the extent of the corroborative evidence that Mr. Estes has about each of these events that may be violations of criminal law. Secondly, the sources of this information. And third, the extent of his involvement, if any, in each of those events or any subsequent cover-ups. Until we have detailed information concerning these 3 things, we can not determine whether any violation of federal criminal law occurred, which are within our jurisdiction to investigate and prosecute, and if so, whether the information is credible and otherwise warrants investigation. Accordingly, if we are to proceed with meaningful discussions concerning Mr. Estes' proffered cooperation, we must receive a detailed and specific written offer of proof from you setting forth the information noted above. The government will hold your offer of proof in strictest confidence and will not make any use of it other than to determine the credibility of the proffered information and whether it warrants further discussions with or debriefings of Mr. Estes. I must make sure that several things are understood at this time concerning Mr. Estes' proffered cooperation. First, if after reviewing your offer of proof we decide the information that Mr. Estes can provide is credible and in all other respects warrants further investigation, a decision will be made unilaterally by the government. It will be necessary for Mr. Estes to be interviewed and to reveal everything he knows about the possible criminal violations. He will have to do so completely, truthfully, and without guile. Second, it must be understood that the government is not now making specific promises to Mr. Estes, except with respect to the confidentiality and use of your offer of proof as noted above. If it is decided that Mr. Estes should be interviewed, the extent of promises concerning the confidentiality or use of the statement or promises of reward or consideration to Mr. Estes, if any, will be determined only after we receive a detailed written offer of proof from you. Above all, I must emphasize that Mr. Estes must act with total honesty and candor in any dealings with the Department of Justice or any investigative agency. If any discussions with or debriefings of Mr. Estes takes place after receipt of your offer of proof, and if any agreement ultimately is reached after Mr. Estes provides a statement, the government will not be bound by any representations or agreements it makes if any of his statements at any time are false, misleading, or materially incomplete, or if he knowingly fails to act with total honesty and candor. Sincerely, Stephen S. Trott, Assistant Attorney General, Criminal Division. Letter number 2, August 9th, 1984, Mr. Stephen S. Trott, Assistant Attorney General, Criminal Division, U.S. Department of Justice, Washington, D.C., 20530, regarding Mr. Billy Saul Estes. Dear Mr. Trott, my client, Mr. Estes, has authorized me to make this reply to your letter of May 29th, 1984. Mr. Estes was a member of a 4-member group headed by Lyndon Johnson, which committed criminal acts in Texas in the 1960s. The other 2 besides Mr. Estes were LBJ, Cliff Carter, and Mac Wallace. Mr. Estes is willing to disclose his knowledge concerning the following criminal offenses. Number 1, murders. The killing of Henry Marshall. The killing of George Krutalik. The killing of Ike Rogers and his secretary. The killing of Harold Orr. The killing of Coleman Wade. The killing of Josepha Johnson. The killing of John Kinzer. The killing of President John F. Kennedy. Mr. Estes is willing to testify that LBJ ordered these killings and that he transmitted his orders through Cliff Carter to Mac Wallace, who executed the murders. In the cases of murders number 1 through 7, Mr. Estes' knowledge of the precise details concerning the way the murders were executed stems from conversations he had shortly after each event with Cliff Carter and Mac Wallace. In addition, a short time after Mr. Estes was released from prison in 1971, he met with Cliff Carter, and they reminisced about what had occurred in the past, including the murders. During their conversation, Carter orally compiled a list of 17 murders which had been committed, some of which Mr. Estes was unfamiliar. A living witness was present in that meeting and should be willing to testify about it. He is Kyle Brown, recently of Houston and now living in Brady, Texas. Mr. Estes states that Mac Wallace, whom he describes as a stone killer with a communist background, recruited Jack Ruby, who in turn recruited Lee Harvey Oswald. Mr. Estes says that Cliff Carter told him that Mac Wallace fired a shot from the grassy knoll in Dallas, which hit JFK from the front during the assassination. Mr. Estes declared that Cliff Carter told him the day Kennedy was killed, Fidel Castro also was supposed to be assassinated, and that Robert Kennedy, awaiting word of Castro's death, instead received news of his brother's killing. Mr. Estes says that the Mafia did not participate in the Kennedy assassination, but that it is possible participation was discussed prior to the event, but rejected by LBJ, who believed if the Mafia were involved, he would never be out from under its blackmail. Mr. Estes asserts that Mr. Ronnie Clark of Wichita, Kansas, has attempted on several occasions to engage him in conversation. Mr. Clark, who is a frequent visitor to Las Vegas, has indicated in these conversations a detailed knowledge corresponding to Mr. Estes' knowledge of the JFK assassination. Mr. Clark claims to have met with Mr. Jack Ruby a few days prior to the assassination, at which time Kennedy's planned murder was discussed. Mr. Estes declares that discussions were had with Jimmy Hoffa concerning having his aide Larry Cabell kill Robert Kennedy while the latter drove around in his convertible. Mr. Estes had records of his phone calls during the relevant years to key persons mentioned in the foregoing account. Number 2, the illegal cotton allotments. Mr. Estes desires to discuss the infamous illegal cotton allotment schemes in great detail. He has tape recordings made at the time of LBJ, Cliff Carter, and himself discussing the scheme. These recordings were made with Cliff Carter's knowledge as a means of Carter and Estes protecting themselves should LBJ order their deaths. Mr. Estes believes these tape recordings and the rumors of other recordings allegedly in his possession are the reason he has not been murdered. Number 3, illegal payoffs. Mr. Estes is willing to disclose illegal payoff schemes in which he collected and passed on to Cliff Carter and LBJ millions of dollars. Mr. Estes collected payoff money on more than one occasion from George and Herman Brown of Brown and Root, which was delivered to LBJ. In your letter of May 29, 1984, you request, number 1, the information including the extent of corroborative evidence that Mr. Estes has about each one of these events that may be violations of criminal law, 2, the sources of his information, and 3, the extent of his involvement, if any, in each of those events or any subsequent cover-ups. In connection with item number 1, I wish to declare as Mr. Estes' attorney that Mr. Estes is prepared without reservation to provide all the information he has. Most of the information contained in this letter I obtained from him yesterday for the first time. While Mr. Estes has been preoccupied by this knowledge almost every day for the last 22 years, it was not until we began talking yesterday that he could face up to disclosing it to another person. My impression from our conversation yesterday is that Mr. Estes, in the proper setting, will be able to recall and orally recount a vast and detailed body of information about these criminal matters. It is also my impression that his interrogation in such a setting will elicit additional corroborative evidence as his memory is stimulated. In connection with your item number 2, Mr. Estes has attempted in this letter to provide his sources of information. In connection with your item number 3, Mr. Estes states that he never participated in any of the murders. It may be alleged that he participated in subsequent cover-ups. His response to this is that, had he conducted himself any differently, he too would have been a murder victim. Mr. Estes wishes to confirm that he will abide by the conditions set forth in your letter, and that he plans to act with total honesty and candor in any dealings with the Department of Justice or any federal investigative agency. In return for his cooperation, Mr. Estes wishes in exchange his being given immunity, his parole restrictions being lifted, and favorable consideration being given to recommending his long-standing tax liens being removed and his obtaining a pardon. Sincerely yours, Douglas Caddy. Letter number 3. September 13th, 1984. U.S. Department of Justice, Stephen S. Trott, Criminal Division. Douglas Caddy, Esquire, Attorney at Law. General Holmes Building, 7322 Southwest Freeway, Suite 610, Houston, Texas, 77074. Regarding Billy Saul Estes. Dear Mr. Caddy, I have received your letter setting forth the specific allegations of Mr. Estes concerning the possible commission of criminal offenses in Texas in the 1960s. While no opinions or conclusions can be drawn at this time concerning the credibility of Mr. Estes' allegation, it is apparent that the detailed debriefing of Mr. Estes concerning these allegations is warranted. Therefore, if Mr. Estes still desires to provide information and evidence supporting his allegations, it is necessary for him to agree to a detailed interview by agents of the Federal Bureau of Investigation. He must further agree to the following. Number 1, to submit to the interview under such circumstances as the government deems appropriate, including the use of a polygraph, in order for the FBI to be able to evaluate the credibility of Mr. Estes' allegations. Number 2, to provide any and all information he has and any and all evidence in his possession or which he has knowledge concerning the matters set forth in your letter of August 9th, 1984, and not to withdraw or withhold any information or evidence concerning such matters. Number 3, to provide any and all information he has and any and all evidence in his possession or of which he has knowledge concerning any other alleged criminal conduct which the FBI may consider to be relevant in assessing the credibility of the information which is at the core of this process. Number 4, to provide all such information completely and truthfully and to act with total honesty and candor at all times, omitting nothing of which he has knowledge that is relevant in this inquiry. You have represented that with regard to the alleged murders, Mr. Estes represents that he never participated in any of the killings. If this representation is true, and if Mr. Estes fully meets each of the requirements above, nothing said or revealed by Mr. Estes in the course of this interview will be used against him in a court of law. If the representation is not true, the government will be free to use the information against him as well as any leads derived from there. Mr. Estes has asked for other specific consideration in return for the information which he says that he possesses. Whether additional consideration will be extended to Mr. Estes and the nature and extent of such consideration will be reviewed, considered, and decided by the government after Mr. Estes has been interviewed. This decision will be made based upon our evaluation of the completeness and truthfulness of Mr. Estes' cooperation and the value and credibility of the information and evidence he provides. At the present time, Mr. Estes will submit to the proposed interview with no promises of any consideration whatsoever other than that nothing he says will be used against him in a court of law if he reveals the complete truth about what he knows. I must emphasize that if Mr. Estes agrees to the conditions set forth in this letter, his obligation is to do nothing other than to candidly reveal the whole truth about the alleged criminal conduct. At all times he shall tell the truth and nothing but the truth. Should any of his statements be false, misleading, or materially incomplete, or should he knowingly fail to act with such total honesty and candor, the promise not to use any statements against Mr. Estes will be null and void, and the government will not be bound by any other representations or agreements it makes. Furthermore, any knowing or reckless untruthful statement itself may be the predicate for criminal charges against Mr. Estes if it appears that he has provided false information which implicates an innocent person in the commission of a crime, or perjures himself while under oath, or makes false statements to the FBI, or otherwise violates any statute in knowingly making such untrue statements. One final comment is in order. The government is aware that general public discussion of allegations of criminal conduct can have an adverse effect upon not only in the investigation of the allegations, but also the reputations of those implicated. This is particularly true with respect to the present matter, given the nature of the allegations and the fact that they concern persons who are not able to respond to them. Therefore, we believe it is particularly important in this matter, as in any other criminal matter, to maintain the utmost confidentiality. No additional promises, agreements will be entered into unless in writing and signed by all parties. Sincerely, Stephen S. Trott, Assistant Attorney General, Criminal Division, agreed to and consented to, blank line, Billy Saul Estes' name underneath, blank line, attorney for Billy Saul Estes underneath. In an interview with Mr. Lyle Sardi, an independent filmmaker and researcher, Douglas Caddy explained some of the circumstances of the time. Stephen Trott, an Assistant Attorney General with the Justice Department, went directly to William Sessions, then Director of the FBI, to get permission to follow up on the Estes matter. Sessions gave him full permission and assigned 3 young, energetic investigators to assist. An effort was made to assign agents who were young and not familiar with the Kennedy assassination or the history of Billy Saul Estes. It was thought that they would be unbiased and fresh in their approach to the case. They opened the files on Estes and the Kennedy assassination and determined that an interview with Estes was necessary. In fact, the young agents were very excited at the possibilities. Flying from Washington, D.C. to Texas for their appointment to interview Estes, the FBI agents were met with a surprise when they met Billy Saul for breakfast, according to Caddy. Estes announced to the agents and Caddy that he had decided not to go forward with the interview and walked away. The agents, Caddy, and Billy Saul's daughter were shocked. No reason was ever given for the aborted session. History still waits for the day when Estes will tell the full and truthful story of his relationship with Lyndon Johnson and the criminal activities they engaged in. The Justice Department dispatched a final, bitter letter to Caddy and Estes. In it, you can feel the frustration of having dealt with the king of the wheeler-dealers, Billy Saul Estes. Letter number 4, the final letter from the Justice Department, November 1st, 1984, U.S. Department of Justice, Stephen S. Trott, Criminal Division, to Douglas Caddy, Esquire, Attorney at Law, General Holmes Building, 7322 Southwest Freeway, Suite 610, Houston, Texas, 77074, regarding Billy Saul Estes. Dear Mr. Caddy, I have been informed by the Federal Bureau of Investigation, which undertook to interview Mr. Estes at my request, based upon your offer of proof and representation that Mr. Estes desired to cooperate under the terms set forth in my September 13, 1984 letter to you, that Mr. Estes refused to be interrogated by 2 agents who spent numerous hours reviewing Bureau files and who traveled to Abilene, Texas from Washington for the sole purpose of interviewing Mr. Estes. Inasmuch as Mr. Estes is unable or unwilling to agree to completely and truthfully reveal to us the information he has, which was the only condition required of him under my letter of September 13th, we have closed the preliminary investigation of the allegations of Mr. Estes. We are compelled to close this matter not only because there simply is no credible evidence of any federal criminal offense, but also because of our promise to you in my letter of May 29, 1984, that we would not use your offer of proof except to make a decision as to whether we should interview Mr. Estes. It must be evident to you and Mr. Estes that we do not take lightly allegations such as he made. The preliminary investigation of his allegation necessitated a substantial redirection of resources of both the FBI and the Department from our other serious matters. While we have promised not to make any use of the information revealed in your offer of proof, it would be wise for Mr. Estes to remember that he is on parole, and if he continues to make allegations which he is unwilling to or unable to support, it is a matter which we will report to his probation officer. Very truly yours, Stephen S. Trott, Attorney General. The importance of these documents is obvious. Like the tip of an iceberg, they show a glimpse of what lies silent below the surface. Unfortunately, the tip was all that the Justice Department and the FBI were to see. This is the way it has remained since 1984. In early 1998, Lyle Sardi was able to contact Kyle Brown, mentioned in the Estes letters, as a witness to some of Estes' activities. Sardi specifically asked Brown about the tapes that Estes purportedly had in his possession, tapes made of LBJ without his knowledge. Brown acknowledged the existence of these tapes and said that he had heard them in their entirety. When asked about the content of the tapes, Brown reported, "Well, they proved that LBJ was a cold-blooded killer, but then we already knew that." Later, Sardi told us that in 1998, a group of investors attempted to buy these tapes from Mr. Estes. A cash offer of $1.5 million was soundly turned down. Do these tapes exist? Many, including Mark and I, think they do. Estes views these tapes as the means of his survival for the past 3 decades, and what he plans to do with them is anyone's guess. One thing is certain, however. Time and Billy Saul's health are slipping away. The aborted 1984 interview needs to be renegotiated and carried out, along with the complete release of the Estes tapes, phone records, and documents. Only then will a complete picture of the assassination and its architects emerge. Closing note to this chapter. Billy Saul Estes died on May 14th, 2013. Madeline Brown passed away June 22nd, 2002. These witnesses are gone.